welcome to Legal Lines. I'm your host, Glenn Smith, and today I have two guests with me. The first I have is Brad Jacobs. Brad is our Register of Wills and the Clerk of our Orphans Court. So welcome, Brad.
Thank you, Glenn.
And along with you, I have your solicitor, Attorney John Harold. So welcome.
Welcome to you.
All right, thank you. So welcome to Legal Lines. Brad, this is, I guess, your, how shall we say it, your swan song?
Bittersweet.
Bittersweet? All right, so after 40 years of public service, since almost 19 years in the current office you hold, you've been doing a lot of good things for this community.
Well, thank you, Glenn. Public service has been my life for the last 43 years between my township, West Manchester Township. I served during those 23 years with Governor Ridge. And in 1999, I was elected to the Register of Wills office and will be completing 20 years, January 3rd, when my successor gets sworn in.
I think that's a well-deserved retirement.
Thank you.
So I also hear tell you're not too shabby of a golfer either.
I haven't been on the golf course recently. I really haven't played in the last couple of years. I had an injury, so and I want to take lessons to learn how to swing as a 75-year-old golfer.
Let me know how that goes.
I will. It's like someone told me, your drive now goes as long as your putt, and maybe it's time to give it up.
I know my father really enjoys hitting it from the senior tees today.
Yes,
so, yeah.
yes. And I'm there.
Good for you. And then we have John. John is a partner with, I want to make sure I get this right, Greist, Himes, Harold, Reynosa, LLP.
Correct.
And your practice specializes in wills and estates as well as municipal and real estate.
Yes, and I do a few other things, but that's the basics of what it is. And there's other people in the office. For example, we have a general practice firm. Two of my partners do nothing but domestic work, and then some of the other associates do other things, criminal work and things like that. So we have a general practice law firm.
Now, you're here today in your capacity as solicitor. And
Correct.
Solicitor is another name for keeping this guy out of trouble?
Exactly.
Okay.
What I do is when certain questions come up in the Register of Wills office or over on the Clerk of the Orphans Court side, there's two separate offices there, but they're both under Brad's jurisdiction, if you will. I get the call, how do we handle this, or what do we do about this? And that's what I'm there for. I'm not in the office on a regular basis.
Mm-hmm. And just to follow up on that, our staff, we cannot give out legal advice, and that's why we have John as our solicitor to answer those questions or give us the direction to go.
Sure. And both of those departments are largely based on what the law or the statute is, right?
Yes, the probate, estate, and fiduciaries code is, in a sense, the Bible for the operations over both offices. It's a unique office in that I run for one office but actually hold two.
Is that common around the state?
Some of the smaller counties, actually, the Register of Wills may be the Recorder of Deeds, also the Clerk of Orphans Court. I think there's 4 or 5 counties that they hold all of the row offices, which is somewhat unique. And that's a smaller county, of course. But third-class counties is a register and clerk.
So your positions are elected positions, right?
4-year terms.
And as we mentioned, you've been holding those hats since 2000.
Yes.
And
yes.
I hear you're the longest tenured register and clerk since 18...
Yeah, the first appointed register, I believe, was 1749 when York County was established. The first elected register was in that time range or year range that you just mentioned, and I am the longest serving elected register clerk.
Congratulations for that.
Thank you.
The Orphans Court. It sounds like you deal with orphans all day long. There's more to it than just orphans, right?
Correct.
What does the Clerk of the Orphans Court do?
First of all, Glenn, we maintain all the records that are related to the Orphans Court Division in the Court of Common Pleas. We do have adoptions, and of course those are sealed records. incapacities where guardianships or guardians are appointed to handle the affairs of that incapacitated individual. We have minor settlement cases where there's a minor that might have been involved in an accident, and there's an insurance settlement, and of course that goes before the Orphans Court judge. So it's a variety of cases that come through Orphans Court.
So what is incapacitated? We might tag John in for this one. We're going to have you guys here as a tag team effort today. What does it mean to be incapacitated?
An incapacitated person is a person who has lost either the mental or physical ability to take care of their financial affairs generally, although it could also be their living arrangements, etc. And the court, the judge of the Orphans Court holds a hearing where the individual's family testifies, and also a doctor would testify that the person does not have the requisite mental facilities because of old age, dementia, or a stroke or something like that to handle their financial affairs, and therefore a guardian is appointed who will manage the financial affairs of the individual and also determine the living arrangements and that sort of thing for the individual who is incapacitated.
And we, as our staff, are involved in all those court hearings. The other thing is, to follow up on John, that guardian will file annual reports to the court of the activities and the assets of that individual.
Can anyone be a guardian?
Actually, the court can appoint anyone that the court wishes to be a guardian. Sometimes it's a family member. Sometimes it's a professional guardian. There are services throughout the country and here in York County where that individual or that organization is appointed as the guardian of the incapacitated person.
Now, we're certainly not giving out legal advice here today, and if you have legal questions, by all means, we recommend contact your attorney, or you can contact the Bar Association for a referral to an attorney. But later in the show, we're going to be talking about some estate planning things that people can do. When we're talking about guardianships, there's ways that one can avoid having to go through a guardianship proceeding with some planning. Is that fair?
That's true, yes. Typically, when a guardian is appointed, there is no power of attorney in place. But if the individual has done some planning and executed a power of attorney, in most instances, that will suffice and avoid the necessity of going to court on a guardianship proceeding.
And they're not always the most pleasant of hearings to have, these guardianships.
No. They're difficult for the family. I mean, it's difficult for the children to have to go into court to have mom or dad declared an incapacitated person. The old term used to be an incompetent. Okay, that's now referred to as an incapacitated person, but still, it's you know, you hear that word incompetency many times. Yeah, it's very emotionally draining for families to have to do that.
And to see a parent brought into a court hearing on a litter from a nursing home or wherever, and go through the process of that incapacitated hearing, it really is difficult for the family.
So, you know, again, we'll be talking a little bit about this later, but another wonderful opportunity, power of attorneys. Certainly avoid some unfortunate situations you might have to go through later on. One of the things you didn't mention, Brad, that your office does, which I would say some of the things are probably not the most pleasant of things, dealing with guardianships, having to deal with death, things of that nature when probating estates. You have adoptions, which are some of the most wonderful things that happen in our courthouse. You also do marriage licenses.
Yes, we do. We issue marriage license. Currently, the fee is $60. Now, not all of that money stays within the county. There's fees established by the Commonwealth. But we do issue a marriage license. Both applicants have to come in at the same time and apply for that marriage license. It's post-dated 3 days. They just can't run out of the judicial center and go to a district magistrate and get married. They have to wait 3 days. And
it's important. Say that again. So if I want to get married, I need to get it 3 days in advance.
Correct.
Okay.
And also, it's good for 60 days anywhere in the Commonwealth. After that 60 days, the license expires. And if they haven't used it, they would have to reapply and get a new marriage license. But when it is used and the officiant sends back his return of marriage that says he married Mary and John on this date, that's when the license is officially recorded in the Commonwealth.
I remember a number of years ago there was a court case which actually sprung out of York County deciding who can and cannot be an officiant for a wedding. Where does that stand today?
Well, today there is legislation in Harrisburg right now to sort of define an officiant. The current statute reads a minister, priest, or a rabbi of a regularly established church. Since the involvement of internet ordinations, that question arises, does that individual have a regularly established church? We don't call ourselves marriage police. Whether that duplicate that comes back to us from the officiant, we don't question his status as far as being ordained or not on the internet, at a seminary, whatever. We don't question that. If someone in the family says that that individual married Mary and John is really not an officiant according to the statute, that would start a process through the district attorney, and that's what happened with Judge Cook's decision, which was probably one of the first decisions in the Commonwealth of Pennsylvania to, in a sense, dissolve a marriage license.
Wow. So I'm going to put you on the spot here. How many marriages did you, or should I say marriage certificates, did you issue last year?
We issue in excess of 2,000.
I looked up the numbers, so I just wanted to see, yeah.
It's over 2,000 marriage license a year. And okay.
Yeah, I had almost 2,500 for last year.
Yeah. Now, we often wonder how many divorces are filed in the pathonetary's office, see if we're ahead of the game. But
I should have looked that up, see what our net gain is on that.
But it's in excess of 2,000. And we do have the ability for the applicants to start their process on the internet now, start their application process, and then they still have to come in, and of course they take an oath that everything on that application is true and correct to their best of knowledge. So.
Okay, great. So we're going to talk a little bit about the Register of Wills. Okay. The name kind of gives it away. It deals with wills, but is it as simple as that? You just deal with wills?
No.
Okay.
If there's no will, then it's called an administration. And of course, the probate and estate and fiduciaries code tells us who would serve in that administration as a personal representative. A will would designate an executor or executrix to handle the affairs of that deceased individual. So, and there's other issues too that can come even if there is a will.
Well, we're going to be getting into some of those a little bit later. We're just about ready to take our break. One of the things I always find interesting is a lot of people don't realize if you don't write a will, I always of the opinion you have one written for you, right? Because the state, through their intestacy laws, dictate a lot about what happens to your stuff.
Right. That's exactly correct, Glenn. There is the Intestate Act that has a specific manner set forth in which an estate is to be distributed when someone dies without a will. And that, it has to be followed by the personal representative. If there is no will, of course, the will gives the individual flexibility on how their estate is to be distributed, and that once that will is in place, then that is what's going to control the distribution of the estate when a person dies.
All right, well, we will be following up on that after our break. We're going to take a few moments here, and we'll be back with you soon. You're watching Legal Lines, brought to you by the York County Bar Foundation. Welcome back to Legal Lines. I'm Glenn Smith. I'm your host. And again, with me today is Brad Jacobs, our Register of Wills and Clerk of our Orphans Court. and his solicitor, John Harold. Welcome back, gentlemen.
Thank you.
Thank you.
Before we took the break, we started talking a little bit about the Register of Wills and the fact that it handles wills and, well, in instances that people don't have wills. So, real basic question. What's a will?
Well, it's one of the most important documents that someone can prepare in their life. And it basically establishes the legacy of your estate, your wishes, whether it be a donation to a contribution to a nonprofit, whatever. It also can control the distribution of your assets, how they're going to be distributed. So it's a definite document that everyone should have, and eliminates a lot of issues if there is no will.
So what constitutes a will? Can I just write it on a cocktail napkin?
The answer to that is yes, you can. A will, to be valid, has to be in writing and has to be signed at the end thereof. Those are the only two requirements to have a valid will. Now, the person who does it has to be over 18 years of age and has to be mentally competent. But to have a valid will in writing and signed at the end thereof. Doesn't have to be dated, doesn't have to have witnesses. So those are things that's all you need to have a valid will. Obviously, a date should be on the will. Witnesses should be on the will, but it's not required in Pennsylvania.
So hopefully I'm getting the terminology right here, but a self-authenticating will? Am I saying that right?
Proven.
Self-proving, that's the word.
Okay, that is, a self-proved will is a will that is properly executed with witnesses with an affidavit attached, signed by a notary, that has to be notarized, that certifies that this is your will, and the witnesses certify that you signed that document as your will, and it's sworn to before a notary. That's a self-proved will. If you don't have a self-proved will, the witnesses who observed the signing of the will when it was originally signed have to go into the courthouse to Brad's office and take an oath that that signature that's on that document is in fact the signature of the testator, the person who signed the will.
And we call that a subscribing witness. Okay. In some cases, though, that subscribing witness might not be available anymore, depending on how old the will was. And then you would have a non-subscribing witness complete that same, in a sense, an affidavit that they can vouch that that is the signature of the decedent. Non-subscribing witness.
So if I can't find a subscribing witness and I don't have one to verify the signature, what happens?
Well, first of all, we can help you with a listing of years of secretaries to lawyers or whatever that worked for firms that we could help you find a non-subscribing witness, or even that to help you get through that process. If you don't have one, I'll let John respond to that if there's no.
Well, if we can't get the subscribing witnesses to come into Brad's office to certify the signature, then we look for non-subscribing witnesses. Now, the non-subscribing witness can be anyone who recognizes the signature on the will as the signature of the decedent. So it can be a child, a brother, a sister, a bank officer, for example.
Business partner,
anyone who can come into the registrar's office and take an oath that they recognize that signature on that document as the signature of the decedent.
I mean, it even goes to the extent we had a bank officer come and say, I looked at the signature card and I saw Mary sign the signature card, and I can, I affirm that that is her signature on the will. I mean, as a non-subscriber.
It's not as daunting a task as it may sound.
No.
It's pretty easy to find two people that can recognize it as the signature of the decedent.
So I have someone in my family that just passed. What happens? Can I go to you and say, Brad, hey, can I have the will so I can go ahead and probate this?
In Pennsylvania, the wills are not recorded in the Register of Wills office until death. So you would need to bring in that original will. it is confusing in our location to Maryland. Maryland receives all the wills in their registrar of wills, and they hold them in that office. But in Pennsylvania, that original will is maintained by the testator who made it, or an attorney who wrote the will for them, or a family member.
So as a tip, it would be a good idea for those of us that have wills to make sure our loved ones or friends know where it can be located.
Yes, that's true. And also it goes back to even to a power of attorney. That person that was designated the power of attorney should know where that original power of attorney is. So,
And I'll add one other caveat to that, Glenn, and that is that the will should be kept in a very safe place so that it's not likely to be lost or accidentally destroyed. And I always tell my clients the safest place is in a safety deposit box in a bank.
Now, I know there's some misnomer out there that when someone dies, the safe deposit box gets locked down, so you may not get access to that right away. Is that true?
Right, John.
You can have access to the safety deposit box in the presence of a bank officer. You can't get the box and take it back to the private room that you could do if you were just the person who owned the box. But when someone dies, a family member can go into the bank with the key to the box and ask that the box be opened in front of a bank officer for a will search, and the will and the deed to the cemetery plot is allowed to be removed at that time. So it's not a problem to get that will out of the safety deposit box after someone dies. It's just that the bank officer has to be present to make sure that nothing else is taken out of the box.
Your county's a pretty big county. I think last time I checked, we may be number 6 in the state, size-wise. We have over 440,000 people residing in our county. How many states do you typically, I don't want to say manage, but maybe manage is the right word, through the course of a year?
Again, it's in excess of 2,000, and some years it's 2,500, depending, of course, on the number of deaths. And of course, if there, in some cases, because there is a death and there's a surviving spouse and everything is in joint ownership, there's no estate open in that particular case, and John can add to that.
Yeah, generally, there's little or nothing that needs to be done with respect to an estate administration when the first spouse dies. Of course, then when the second spouse dies, that's when the estate administration takes place, because most spouses hold their assets as tenants by the entireties, which means that they're jointly owned, and when the first spouse dies, ownership automatically passes to the surviving spouse.
So we need the executor or executrix to bring in that original will. We would ask them to bring a copy along also. If we have to make a copy, of course, there is a charge from the office to make that photocopy. And we give that photocopy back to them in a blue back when we grant letters authorizing them to handle the affairs.
Do I need to bring anything else to your office?
Death certificate. Need the original death certificate.
One of the functions of your office is to handle inheritance tax.
That's probably one of the most unpleasant duties as register that you have. Last year, we collected in excess of $26 million in inheritance tax. I tell the story. The Commonwealth tells us what banks to use to make that deposit, and in New York, it's Wells Fargo. And I tell people, if you ever see the stagecoach going north on 83, don't try to stop it because they're armed and there's a lot of money in there going north. But it's in excess of $26 million a year. And for 19 years, we've collected almost $400 million in inheritance tax out of York County estates. Now, to compare that to the Commonwealth, 67 counties, the Department of Revenue, the last fiscal year received $1.1 billion, that's a B, billion dollars. That just goes into the general fund in Harrisburg. Every year the legislators come up with legislation to eliminate inheritance tax. Most of those bills don't see the light of day, although we've had some changes to the inheritance tax code, farms, where family farms are transferred to a family member that eliminated inheritance tax, and we now just had a change on children under 21 years of age, 0% inheritance tax. So there are some changes, but slight.
Does your county ever get any of that back? It sounds
We
like
do.
a lot of it's going to Harrisburg.
We do. As registrar, I act as agent for the Department of Revenue, and they return to the county a percentage. It's 0.005%. It usually, and that you can take $26 million and take that times that, it's excess of $100,000. It comes back into the general fund for the efforts of my office collecting that tax
And that all goes into the general fund.
of York County.
So that helps us
And that-
with our
yeah.
tax base here.
It does. But you hate to see all that money going north.
Certainly. Maybe it'll offset some of our property tax. That's a conversation for another day. So, does everybody need a will? I don't have a lot. I'm young. I don't have a lot of assets.
No.
Should I have a will?
Well, everyone should have a will. It's your way of handling the assets that you accumulated over your lifetime, regardless of what that might amount to.
And does it include my life insurance?
No, that's not part of the, and it's not in part of the inheritance tax on that life insurance benefit. But real estate, savings, any financial savings.
As a general rule of thumb, things that have beneficiaries, things of that
Yeah.
nature are not included in the probate. They go outside of
Outside.
the estate.
That's
not
correct.
probated.
Like 401ks, life insurance annuities, they're paid to the designated beneficiary and are not controlled by the will.
And this goes back to, your lifetime accumulations. You're going to determine how they're going to be distributed to your heirs.
So I wrote my will. It's 10 years ago. Locked it away. It's in my safe deposit box, as John suggested. Do I need to pull it out?
I always tell people a will is a living document. Things change in your life, whether it might be a divorce, grandchildren, whatever. You should keep the will current as far as your life is going with family or whatever. So, no, you don't have to pull it out. You can make changes to the will with a codicil or an amendment to the will. You don't have to rewrite the will. You can make a delineation of deletion from a certain section of the will and add a codicil. And of course, as John would say, that has to be signed, dated, witness thereof.
Exactly.
Well, we're just about out of time, but I'm going to ask you one final question. Do you need an attorney to write a will?
No, but we always recommend it, and I'll let John pick up on that.
You can write your own will, but remember, you're not going to be here to tell us what you meant if it's not clear what you wrote. I always recommend that there are two documents that should be prepared by an attorney, the will and a financial power of attorney.
Thank you so much, John. We're out of time, folks. Brad, I'd like to
Thank you,
thank
Glenn.
you for 40 years.
Thank you.
You will be missed. John, thank you for coming out as well. We appreciate it.
Pleasure to be here.
I'm Glenn Smith. This has been Legal Lines, and we'll see you next time.